So, we'll discuss Dower as a charge. Ordinarily, the dower is not a charge on the property of the husband, though one may be created by agreement or by a decree of a court. And regarding that, Mullah opines that although it is within the competence of the court to create a charge, it should not ordinarily do so, as thereby the dower debt gets priority over the debt of other creditors, and therefore the court should do is to pass a simple money decree. It is submitted that the purpose of creating a charge is to give priority to the dower debt over the unsecured debt of their creditors. And regarding the right of retention, as we'll discuss the very important leading case, that is I.MainaBibi versus Vakil Ahmad, as it was decided in 1924 by the Privy Council. Also, another important case, that is Ghouse Khan versus Fatima by Begum in 1988 by the Andhra Pradesh High Court. So, in I.MainaBibi versus Vakil Ahmad, the Privy Council explained the right of retention as the possession of property being once peacefully acquired, the right of the widow to retain till her dower debt is paid is conferred upon her under Muslim law. As it was decided in this above case, as on the death of her husband in 1870, the widow I.MainaBibi entered in possession of her husband's property. In 1902, some legal heirs of the husband filed a suit to obtain possession of their share. The widow inter alia pleaded that her possession was in lieu of her dower in the exercise of her right of retention. In 1903, the trial court passed a decree in favor of the legal heirs on the condition that they paid certain sum of money together with interest to the widow towards her dower. No amount was paid to the widow, and she continued in possession of the property. In 1907, the widow made a gift of this property, which was challenged by the legal heirs, and the Privy Council held that the whole the property, the widow merely had a right of retention of possession till she was paid. She could not alienate or otherwise deal with the property. And regarding the very controversy on consent, as we discuss, there is still some controversy under the whether the very possession of the widow or divorcee should be with the consent express or implied of the husband or the heirs. The controversy arises on account of certain observation made by the Privy Council in Hamira Bibi versus Jubida Bibi, but the High Courts of Calcutta in I.Sabur versus Ismail in 1924 and Muhammad Jubair and Sakina in 1942 by the Patna High Court and Izhar Fatima Ansar in 1939 by the Allahabad High Court, so also in Bijubi Said Murtaz in 1920 by the Madras High Court and Hamidiya versus Halimunnissa in 1952 by the Bombay High Court regarding the very controversy of consent. The High Courts of Calcutta, Patna and Allahabad held that the consent is necessary. On the other hand, the High Courts of Madras and Bombay held that such consent is not necessary. It is submitted that in view of the very nature of the right of retention, the views expressed by the High Courts of Madras and Bombay would be preferable, and regarding the very implications of retention, we'll discuss in the next upcoming